हाय फ्रेंड्स, वेलकम टू माय चैनल। आज मैं आपके लिए द भारतीय साक्ष्य अधिनियम 2023 के बेयर एक्ट का इंडेक्स लेके आई हूँ। बिफोर स्टार्टिंग दिस वीडियो आई वुड लाइक टू एडवाइस कि जो इंडेक्स के सेक्शंस मैं आपको बताने जा रही हूँ वो आप एकदम सारी की सारी वीडियो इकट्ठे प्ले मत करें, छोटे छोटे पार्ट्स में। जैसे आप पहले 2 मिनट की वीडियो सुन ले, लेट्स से कि आपने 30 सेक्शंस तक एक बार ही सुन लिया, उसको फिर से रिपीट करें। जब आपको 30 सेक्शन से थोड़ी सी फैमिलियरिटी हो जाएगी तो आप उसमें और सेक्शंस ऐड कर दें। इससे आपको अच्छे से बेयर एक्ट का इंडेक्स ग्रास्प हो जाएगा। नाउ लेट्स स्टार्ट विद द बेयर एक्ट। पार्ट 1, चैप्टर 1, प्रिलिमिनरी। सेक्शन 1, शॉर्ट टाइटल, एप्लीकेशन एंड कमेंसमेंट। सेकंड, definitions. Part 2, chapter 2, relevancy of facts. Section 3 is evidence may be given of facts in issue and relevant facts. Section 4, relevancy of facts forming part of the same transaction. Section 5, facts which are occasion, cause or effect of facts in issue or relevant fact. Section 6, motive, preparation and previous or subsequent conduct. Section 7, facts necessary to explain or introduce fact in issue or relevant facts. Section 8, things said or done by conspirator in reference to common design. Section 9, when fact not otherwise relevant become relevant. Section 10, facts tending to enable court to determine amount are relevant in suits for damages. 11, facts relevant when right or custom is in question. 12, facts showing existence of state of mind or of body of bodily feeling. 13, facts bearing on question whether act was accidental or intentional. Section 14, existence of course of business when relevant. Section 15, admission defined. Section 16, admissions by party to proceeding or his agent. 17, admissions by persons whose position must be proved as against party to suit. 18, admissions by persons expressly referred to by party to suit. 19, proof of admissions against persons making them and by or on their behalf. 20, when oral admissions as to contents of documents are relevant. 21, admissions in civil cases when relevant. 22, confessions caused by inducement, threat, coercion or promise when irrelevant in criminal proceeding. 23, confession to police officer. 24, consideration of proved confession affecting person making it and others jointly under trial for same offence. 25, admissions not conclusive proof but may stop. 26, cases in which statement of relevant fact by a person who is dead or cannot be found etc. is relevant. 27, relevancy of certain evidence for proving in subsequent proceedings truth of facts therein stated. Section 28, entries in books of account when relevant. 29, relevancy of entry in public record or an electronic record made in performance of duty. 30, relevancy of statement in maps, charts and plans. 31, relevancy of statement as to fact of public nature contained in certain acts or notifications. 32, relevance as to any law contained in law books including electronic or digital form. Section 33, what evidence to be given when statement forms of a conversation, document, electronic record, book or series of letters or papers. 34, previous judgments relevant to bar a second suit or trial. 35, relevancy of certain judgments in probate etc. jurisdiction. 36, relevancy and effect of judgments, orders or decrees other than those mentioned in section 35. 37, judgments etc. other than those mentioned in sections 34, 35 and 36 when relevant. 38, fraud or collusion in obtaining judgment or incompetency of court may be proved. 39, opinion of experts. 40, facts bearing upon opinions of experts. 41, opinions as to handwriting and signature when relevant. 42, opinion as to existence of general custom or right when relevant. 43, opinion as to usages, tenets, etc. when relevant. 44, opinion on relationship when relevant. 45, grounds of opinion when relevant. 46, in civil cases, character to prove conduct imputed irrelevant. 47, in criminal cases, previous good character relevant. 48, evidence of character or previous sexual experience not relevant in certain cases. 49, previous bad character not relevant except in reply. 50, character as affecting Damages. Part 3 on proof. Chapter 3 facts which need not be proved. 51. Facts judicially noticeable not to be proved. 52. Facts of which court shall take judicial notice. 53. Facts admitted need not be proved. Chapter 4 of oral evidence. 54. Proof of facts by oral evidence. Section 55. Oral evidence to be direct. Chapter 5 of documentary evidence. Section 56. Proof of documents. 57. Primary evidence. 58. Secondary evidence. 59. Proof of documents by primary evidence. 60. Cases in which secondary evidence relating to documents may be given. 61. Electronic or digital record. 62. Special provisions as to evidence relating to electronic record. 63. Admissibility of electronic records. 64. Rules as to notice to produce. 65. Proof of signature and handwriting of person alleged to have signed or written document produced. 66. Proof as to electronic signature. 67. Proof of execution of document required by law to be attested. 68. Proof where no attesting witness found. 69. Admission of execution by party to attested document. 70. Proof when attesting witness denies execution. 71. Proof of document not required by law to be attested. 72. Comparison of signature, writing or seal with others admitted or proved. 73. Proof as to verification of digital signature. Section 74. Public and private documents. Section 75. Certified copies of public documents. 76. Proof of documents by production of certified copies. 77. Proof of other official documents. 78. Presumption as to genuineness of certified copies. 79. Presumption as to documents produced as record of evidence, etc. 80. Presumption as to gazettes, newspapers and other documents. 81. Presumption as to gazettes in electronic or digital record. 82. Presumption as to maps or plans made by authority of government. 83. Presumption as to collection of laws, reports of decisions. 84. Presumption as to powers of attorney. 85. Presumption as to electronic agreements. 86. Presumption as to electronic records and electronic signatures. 87. Presumption as to electronic signature certificates. 88. Presumption as to certified copies of foreign judicial records. 89. Presumption as to books, maps and charts. 90. Presumption as to electronic messages. 91. Presumption as to due execution, etc. of documents not produced. 92. Presumption as to documents 30 years old. 93. Presumption as to electronic records 5 years old. Now move to next chapter, chapter 6 of the exclusion of oral evidence by documentary evidence. Section 94. Evidence of terms of contracts, grants and other disposition of property reduced to form of document. 95. Exclusion of evidence of oral agreement. 96. Exclusion of evidence to explain or amend ambiguous document. 97. Exclusion of evidence against application of document to existing facts. 98. Evidence as to document unmeaning in reference to existing fact. 99. Evidence as to application of language which can apply to one only of several persons. Section 100. Evidence as to application of language to one of two sets of facts to neither of which the whole correctly applies. Section 101. Evidence as to meaning of illegible characters, etc. Section 102. Who may give evidence of agreement varying terms of document. Section 103. Saving of provisions of Indian Succession Act relating to wills. Part 4. Production and effect of evidence. Chapter 7 of the burden of proof. Section 104. Burden of proof. Section 105. On whom burden of proof lies. 106. Burden of proof as to a particular fact. 107. Burden of proving fact to be proved to make evidence admissible. 108. Burden of proving that case of accused comes with exceptions. 109. Burden of proving facts especially within knowledge. 110. Burden of proving death of person known to have been alive within 30 years. 111. Burden of proving that person is alive who has not been heard for 7 years. 112. Proof as to relationship in the case of partners, landlords and tenant, principal and agent. 113. Burden of proof as to ownership. 114. Proof of good faith in transactions where one party is in relation of active confidence. 115 presumption as to certain offences. 116 birth during marriage conclusive proof of legitimacy. 117 presumption as to abetment of suicide by a married woman. 118 presumption as to dowry death. 119 court may presume existence of certain facts. 120 presumption as to absence of consent in certain prosecution for rape. Chapter 8 Estoppel. 121 Estoppel. 122 Estoppel of tenant and of licensee of person in possession. 123 Estoppel of acceptor of bill of exchange, bailee or licensee. Chapter 9 of witnesses. 124 who may testify. 125 witness unable to communicate verbally. 126 competency of husband and wife as witnesses in certain cases. 127 judges and magistrates. 128 communications during marriage. 129 evidence as to affairs of state. 130 official communications. 131 information as to commission of offences. 132 professional communications. 133 privilege not waived by volunteering evidence. 134 confidential communication with legal advisors. 135 production of title deeds of witness not a party. 136 production of documents or electronic records which another person having possession could refuse to produce. 137 witness not excused from answering on ground that answer will criminate. 138 accomplice. 139 number of witnesses. Chapter 10 of examination of witnesses. 140 order of production and examination of witnesses. 141 judge to decide as to admissibility of evidence. 142 examination of witnesses. 143 order of examinations. 144 cross examination of a person called to produce a document. 145 witnesses to character. 146 leading question. 147 evidence as to matters in writing. 148 cross examination as to previous statements in writing. 149 questions lawful in cross examination. 150 when witness to be compelled to answer. 151 court to decide when question shall be asked and when witness compelled to answer. 152 question not to be asked without reasonable grounds. 153 procedure of court in case of questions being asked without reasonable grounds. 154 indecent and scandalous questions. 155 questions intended to insult or annoy. 156 exclusion of evidence to contradict answers to questions testing veracity. 157 question by party to his own witness. 158 impeaching credit of witness. 159 questions tending to corroborate evidence of relevant fact admissible. 160 former statements of witness may be proved to corroborate later testimony as to same fact. 161 what matters may be proved in connection with proved statements relevant under section 26 or 27. 162 refreshing memory. 163 testimony to facts stated in document mentioned in section 162. 164 right of adverse party as to writing used to refresh memory. 165 production of documents. 166 giving as evidence of documents called for and produced on notice. 167 using as evidence of document production of which was refused on notice. 168 judge's power to put questions or order production. Chapter 11 of improper admission and rejection of evidence. Section 169 no new trial for improper admission or rejection of evidence. Chapter 12 repeal and savings. Section 170 repeal and savings. So friends, this was all about the index of the भारतीय साक्ष्य अधिनियम 2023. अगर आपको ये वीडियो अच्छा लगा हो काइंडली सब्सक्राइब माय चैनल और जिन्होंने मेरा पिछला वीडियो नहीं देखा है आई वुड एडवाइस कि वो उसको जरूर देखें और जो स्टूडेंट्स ऑलरेडी इसी साल किसी एग्जाम में अपीयर हो रहे हैं उन्हें डाउट्स हैं कोई क्वेरीज हैं यू आर मोस्ट वेलकम यू कैन कॉन्टेक्ट मी ऑन माई ईमेल एड्रेस. थैंक यू फॉर वॉचिंग माई वीडियो. बाय बाय.